So you get a knock on the door. You open the door, somebody you've never seen before. They hand you some paperwork. You look at it. It's a summons. It's a complaint.
You've been served.
Now what? Well, first thing you need to do is to establish what level of court you're being sued in. There's multiple levels of the court system. There's small claims, which is up to $5,000, special civil, which is up to $20,000, and then there's law division, which is over $20,000. The general public gets sued between the special civil division, which is up to $20,000, and the law division, which is over $20,000. So I want to talk about what happens if you get sued at the law division. So like I said earlier, the law division handles cases that are above the $20,000 threshold. A lot of the law division cases are either personal injury cases, you've been involved in a car accident, contractors being sued, or a contractor suing somebody. These are amounts that are typically large amounts, $20, $30, $40, $50,000 and above. I've handled law division cases in the millions of dollars, but it really just depends on the nature of the case because every case is unique. I will say this right off the bat, the first thing you should do when you receive a summons and complaint, speak to an attorney. Do not think that you could handle this by yourself. I can tell you that I've been up against many pro se. Pro se means you're representing yourself, and it does not end well. The court system is very complicated. It's very convoluted. There's a rule that says that judges and the court system cannot treat you any differently than they would treat an attorney. Meaning, when you go to court representing yourself, you're going to court as an attorney. You need to understand the rules. You need to understand the procedure. You need to understand how to introduce evidence. You need to understand how to respond. Everything that an attorney does, you will need to do. Obviously, most attorneys go through extensive training. They have law school. They're in practice. They should know how to navigate the court system. You don't. If you don't have the training, you do not know how to navigate the court system. So I keep stressing it, but the first thing you should do is have a conversation with an attorney, and maybe more than one attorney. Now, what that attorney will do as far as strategy depends on the nature of the case. So I'm going to use a basic case example to give you an idea on how to navigate a law division lawsuit. Let's say you're a contractor and a homeowner is suing you for $100,000. That would obviously meet the threshold. You're a New Jersey contractor, they're a New Jersey homeowner. Jurisdiction is not an issue. That means both parties are from New Jersey, and you receive this lawsuit. Your attorney is most likely going to file an answer and something called affirmative defenses. An answer is basically a response to everything that they're accusing. I'm going to oversimplify it. I, the homeowner, hired this contractor. I gave them $100,000. They didn't do the work. I want my $100,000. Again, I'm oversimplifying it. Your attorney will respond with, that's not true, and give specific defenses as to why that's not true. Now, there's boilerplate, they're called affirmative defenses. And the reason why you put affirmative defenses in your answer is because if you don't raise them in your answer, you waive them later on. So that's why it's really important to get an attorney to file for you, file an answer, file your defenses. Now, I didn't even talk about counterclaims or cross motions or indemnification or bringing in other parties. For example, if that contractor has insurance and he submits a claim for what this person is suing them for, and that insurance company denies that claim, you can actually bring in that insurance company for something called indemnification, saying, hey, you need to cover me. I pay for insurance. You should cover me. You have an attorney file an answer for you. Like I said, that attorney's going to file defenses. They might file cross motions. They might file counterclaims, so on and so forth. Let me give you an example of a counterclaim. Let's say the contractor sued for $100,000, and in reality, the homeowner didn't pay the remainder of their bill. They actually owe the contractor $30,000. That contractor, through their attorney, would file a counterclaim for that $30,000. Let's say you don't file that counterclaim, and you file an answer by yourself, and that lawsuit's resolved, and you end up winning. Now you go back to court and you say, hey, that person owes me $30,000. I want to sue you. You can't do that. There's something called res judicata. It means the case is adjudicated, the case rests. Anything that arises out of the same transaction or occurrence has to be in the same complaint and embodied in that same lawsuit. You cannot now come later on and raise new issues. Just like the person who sued you after the case is resolved can't come back and say, oh, they owe me $10,000 more. They can't do that. As the case proceeds through the court and after your attorney files the answer, counterclaim, or whatever responsive pleadings they feel like need to be filed, it'll go through the discovery phase. Now, discovery is very involved, and that's where the case can become incredibly time-consuming. I just want to give you a blanket overview of what the discovery process looks like. You have interrogatories, which are questions asked of you pertaining to the case. You have notices to produce, basically documents. In the example that I gave where a homeowner sues a contractor, they would want copies of their insurance policy. The contractor would want pictures, proof of the bad work, proof that the money's owed, proof that they gave the contractor the money. Those are just some examples. And then you have depositions. So depositions are basically interviews given under oath where the person asking for that deposition would either do it on Zoom or in person. They would ask you questions, answer those questions under oath, and those questions would be used as part of the discovery process. Now, once the discovery end period is over, either party has a chance to do something called a summary judgment motion. I want to briefly touch on summary judgments because they are important tools when it comes to the law division. Again, they are used in the other divisions, but they're often used in the law division. So we talked about discovery and we talked about depositions, notice to produce, interrogatories, and all of that. So keep that in mind when listening to the court rule. The court rule says that a judge will grant summary judgment if the pleadings, depositions, answers to interrogatories, and admissions on file, together with all the affidavits, show that there's no genuine issue of material fact, then the moving party is entitled to a summary judgment. Now, you have to keep in mind that when the judge reviews a motion for summary judgment, they're reviewing it in a light most favorable to the non-moving party. So that means that they're giving the non-moving party, meaning the person who the case is against, the benefit of the doubt. And the judge has to look at this and say, even if I give the person the benefit of the doubt and I take everything they say as fact, they still lose. It's a tough standard. I've met it before. I've also lost it before. So it's a very tough standard. But if you meet that standard, the judge may grant summary judgment. If you're the contractor on the case study that I just gave and the homeowner files a summary judgment and they win, that's it, you lose. There's a judgment against you, and although you have a right to appeal, very difficult to file an appeal. I'm not going to get into that in this video because appeals are their own animal, but if there's a summary judgment against you, it's a big problem. Let's say the moving party files a summary judgment and they lose. At that juncture, there's something called an arbitration. Most cases through the law division go through arbitration. What happens during an arbitration is simple. The plaintiff, which is the moving party, files an arbitration statement. Here's my case. Here's what I've proven. Here's my results from my deposition, my interrogatory. Look what they said in the deposition. The contractor admitted to messing up. He admitted to cashing the check. There's no issue. The defense will then submit their arbitration statement. And obviously they're going to say, no, that's not true. And an arbiter, which is a neutral third party, typically assigned by the court, usually it's a practicing attorney, will sit down. We'll go through both arbitration statements. He will hear arguments from both sides, and he or she will make a decision on what they believe should be the resolution of the case. That does not mean you have to accept that decision. All that means is that here's what may happen if you go in front of a judge. Now, I will say this. Arbiters, for the most part, they're not judges. They're just typically practicing attorneys who have many cases. From my experience, most arbiters do not have the time to go through every single document concerning your case. However, I believe it's a good tool to gauge what the court may do. Now, you get an arbitration decision, you don't have to accept it. If you do accept it, you do nothing. You have 30 days before that arbitration decision becomes final. So, let me give you an example. If the arbiter in that construction example I gave says that, well, you're suing for $100,000, I don't think you're entitled to $100,000. I think you're entitled to $50,000 based off what I looked at, right? In that situation, they would give an arbitration award of $50,000. One side, if they don't agree with the award, would need to file something called a de novo. And that's essentially telling the court, I do not agree with the arbiter's decision. Please list the case to the trial calendar. Once the case is listed to the trial calendar, the case will proceed in its due course as it was intended. If neither side files a de novo, that's it. That $50,000 arbitration award that I spoke about earlier, that is now the final judgment. That is now what the defendant owes. I've seen cases where attorneys forgot to file the de novo, and the court does not tolerate that. If on day 31 you do not file that de novo, that's it. If the arbiter believed that you're entitled to nothing and he wrote 0 on the arbitration award and your attorney forgets to file the de novo, or if you don't hire an attorney, even worse, you forget to file the de novo, guess what? You get donut hole. As you've heard me speak, it's a very complicated system. You need to have an attorney that knows what they're doing and has navigated the system before. I want to talk about if you lose. What happens if you lose? That's the concern of a lot of clients of mine is, what if there's a judgment against me? What do I do? If you're sued as an LLC, a limited liability corporation, or an incorporation, and that lawsuit is filed only against the corporation and you lose, the judgment will be only against the corporation. Now, if that lawsuit was filed against you personally, that judgment will be against you personally. A lot of the public believes that if you have a judgment against you, the person that owns the judgment can go to the sheriff's office. Sheriff's office will hunt you down, find you, flip you upside down, shake you till all the money comes out to satisfy that judgment. That's not what happens. When there's a judgment against you, it's real simple. It's a piece of paper. It says A owes B X amount of money. And underneath that, it has interest, court costs, attorney's fees, and anything additional the court felt like you were entitled to. That judgment stays on record for 20 years. What does it mean for a judgment to stay on record, right? That's such a broad thing to say. I'm gonna give you an example. If you're selling your home and you have a judgment against you, the buyer of your home is going to do a title search. When they do the title search, all judgments that are against you come up. That judgment is a lien. In order for you to sell your home, you have to pay off that judgment. I'll give you another example. If you have a bank account, and let's just say the judgment is for $50,000, and you have $20,000 sitting in a bank account, the person who has the judgment can apply to put a levy on that bank account for the court to remove the money from that bank account. But there's something you have to keep in mind. Somebody who's been sued and has judgments or a judgment against them, they typically don't keep money in the bank. So don't think that you're just going to go attach a judgment to a bank account or a house. I could tell you from experience, and again, this is a very general statement. Typically, people who have a home try to avoid having judgments. People who have bank accounts with money in it typically avoid having judgments. I have a lot of people that call my office and say, I have a judgment from 11 years ago and I can't find the person. They don't have a bank account. I've been chasing them down. That's the problem with getting a judgment. And that leads me to the next portion of this video that I want to talk about, and it's mediation. At certain stages in your case, you can engage in voluntary or court-ordered mediation. Voluntary mediation it could be pre-litigation, meaning before anyone filed a lawsuit. It could be during the litigation if the attorneys or the parties feel like a four-way mediation, four-way meaning attorney-client, meet and kind of try to facilitate a mediation. It could happen. But I want to read a quote from Abe Lincoln that a judge that I appear in front of often reads at the beginning of every calendar call. And I really like that he does that because it gives all the parties in the courtroom an idea of how important it is to try to mediate your case. And he gave this speech to a group of law students. Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser, and he used that word, loser, in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good person. There will still be enough business. This was written a long time ago. You're talking 150 years or more ago. Sometimes there's situations where you just cannot resolve your case. The two parties are too far apart, but that doesn't happen often. What I tell my clients is, look, you could either pay me to fight, the other party can pay their attorney to fight, or everybody can come to an agreement and walk away with something. Thanks for watching, guys. If there's any other area of law that you want me to expand on, comment down below. Otherwise, like, subscribe, and I'll see you on the next one.